And call the case.
Good afternoon, Your Honors. Matters before the court this afternoon are the consolidated cases entitled In Re Northwestern Medical Center Fiscal Year 2024 and In Re Rutland Regional Medical Center Fiscal Year 2024, case numbers 23 AP 356, 23 AP 357. Representing the appellants, Northwestern Medical Center, Rutland Regional Medical Center, it's Christina Jensen. Representing the appellee, Green Mountain Care Board, it's Ryan Kane.
Okay, thank you, counsel.
Good morning.
Please introduce yourself and your client. Proceed.
Thank you. I said good morning. I think it's afternoon now.
Well, we're taking it, right, we've been, we don't know. So
I'm Christina Jensen with Primer, Piper, Eggleston, and Kramer, and I represent the appellants in these cases, Northwestern Medical Center and Rutland Regional Medical Center.
thanks, Lynn.
The question before the court here is what limits there are on the board, the Green Mountain Care Board's authority to impose conditions in the hospital budget review process. If the court takes the board's position, there won't be any limits on it. What the board did in this case was to impose a new substantive condition without any evidence supporting it, without any findings explaining it, after the board had approved the hospital's budgets as submitted. And
Can I stop you right there?
absolutely.
Repeatedly through your brief, you represented a few times that the budget was approved as submitted, but both the written budget and the oral vote at one of the hearings said it was approved as submitted subject to conditions. Do you agree that it was always subject to conditions, that language was used by the board?
Language very similar to that was used by the board, but I think with a critical distinction. The approval of the budgets was initially approved as submitted, subject to the standard conditions to be finalized. And what that gives us is a couple of things. Number one, that the standard condition, concept of standard conditions, are that they apply to budgets uniformly. For example, you have to submit your year-to-date numbers by March 15th. That would be an appropriate standard condition. What the board did here was to impose a new substantive condition that hadn't been even voted on prior to the board's approval of the budgets as submitted. So you're correct that the board had always attempted to reserve the right to impose conditions, but our position is that the cap imposed was a new substantive condition unsupported by the evidence or the findings, and which actually changed the budget which had been approved.
When was that, Ms. Jensen? When the cap was included for both Rutland and for Northwestern?
The cap was actually included on October 1st. It first appeared in the written order that the board issued after its oral approval of the budgets as submitted.
But the standard budget conditions that were part of the budgeting process did include a commercial rate cap, and they use those words with without having any specific numbers in there. So it was fairly apparent that there was going to be a cap on commercial payers, was there not?
Beginning August 30th, the board began to consider imposing an unspecified cap at a payer level on commercial rate increases. But that cap, the cap itself, includes the numbers that were imposed on the hospitals.
But and correct me if I'm wrong, my understanding is you're not complaining about the fact that the 6% for Northwestern and the 5.6 for Rutland, you're complaining about those. You're complaining about the whole process having a cap included as part of the budget, is it not?
We're complaining about all of the above, actually. So the process by which the cap was imposed was without due process to the hospitals. They never had notice that the board was even considering imposing a cap until August 30th. Prior to August 30th, the budgets had been carefully prepared by the hospitals in accordance with the requirements published by the board on March 30th. Those budgets were due by July 1st and had already been presented to the board and the public prior to the board's ever considering imposing a cap on commercial rate increases. The evidence that the board requested in support of budgets was always in the aggregate. The board never requested disclosure of commercial rate increases on a per payer level. So the board, even if it had wanted to properly impose that condition, it never requested the information that would have been necessary for it to exercise its discretion appropriately.
Would you
How-
I'm sorry.
No, you go ahead.
Would you clarify something for me? Was the cap that the board imposed, did it somehow change the budget or the proposed budget that was before them?
It did, Your Honor.
How so?
Well, that's particularly clear in the case of the Northwestern budget. The Northwestern budget called for a 7.1% increase in inpatient charges and a 0% increase in outpatient charges. That comes out to a weighted average of 6%. What the board did was impose a 6% cap on a per payer basis on commercial charges, which is above the threshold for outpatient services and below the threshold for inpatient services. So what the board did was take aggregate numbers and impose them as a per payer cap. And I think it's very clear, particularly in the case of the Northwestern budget, that that 6% limit is inconsistent with the budget as approved.
Can I ask a question here?
Sure.
On August 30th, it became apparent that there was going to be a commercial rate cap of some kind, correct?
It became clear that the board was considering it for the first time.
Okay.
Yes.
And the budget were approved on October 1st. Is that right?
The budgets were approved orally on, I believe, August 30th. We should have a figure somewhere. But they were approved orally before September 15th.
Okay.
When the condition was voted on. And then the written order purporting to memorialize that oral approval was issued on October 1st, which is the first day of fiscal year 24.
Okay. So during that period of time, what did the hospitals do to preserve their position here that this is unfair and improper?
I'm not sure that the hospitals, first of all, could have done anything in the interim for a couple of reasons. First of all, the hospitals were not aware of the numbers that would be inserted by the board in this proposed cap.
But I thought I understood your position to be it doesn't matter what the number is, they can't do it.
Well, did I not object to everything? A couple of different problems here. The imposition of the cap without notice to the hospitals in time to prepare their budgets to account for it and in time to meaningfully respond to it in the hearings before the board was itself a violation of due process and prevented the hospitals from taking any meaningful action in response to it.
But if I got this wrong, the guidance I've got in my notes, that the FY24 guidance that was issued the end of March said the board may adjust requested commercial rate increases. Isn't that notice?
I don't think that it is, Your Honor, because an adjustment of commercial rate increases is not the same as limiting commercial rate increases on a per payer basis when the board didn't have any information that would have supported its decision to impose a per payer cap. So even if the board had placed the hospitals on notice, it still needs to exercise its discretion in a manner supported by the evidence before it and its findings of fact, and it didn't do that. Additionally, the guidance provides that the board will adjust budgets that don't meet the benchmarks and where the assumptions aren't reasonable. In these cases, in the case of Rutland, the budget was one of, I believe, 2 before the board that actually met the benchmarks. It was a very carefully crafted budget, and the board found that their assumptions were reasonable. Our position is that the board cannot then, in accordance with its own regulations, adjust that budget by imposing a per parent cap as it did here. In the
But
case,
I still don't understand, how is that adjusting a budget? I mean, you're not suggesting that was a modification, are you? Or are you?
oh, I am, absolutely. Yes, the cap.
So how can it be, I'm sorry, how can it be considered a modification if, as the chief just noticed, it was in the conditions that there might be adjustments to these rates? How is it a modification when the board let the hospitals know that this is going to be something that's likely included in your budget?
Well, the guidance did not suggest that any per payer cap would be imposed on budgets. And that appears not only from the language of the guidance, in which no reference to a cap ever existed.
So should they be clear always then on, use language in the document they send out? We may lower, we may increase, we may cap. I mean, how far do they have to go to explain that there might be adjustments to these rates? I mean, how specific do they have to be in these documents?
Well, in this case, there's no way the hospitals could have known that the board was contemplating a per payer cap on commercial rate increases. First of all, not only does it not appear in the guidance specifically provides that the board will only adjust budgets that don't meet the benchmarks and are not based on reasonable assumptions. In both of these cases, the board provided in its orders that adjustment of the budgets was not appropriate. So to then go on and impose a per payer cap that's inconsistent with the budgets as presented was an adjustment not supported by the board's own regulations and inconsistent with its own findings in the orders.
And you responded to, I think it was Justice Ian's question about preservation, that you didn't have an opportunity to do that. There were several meetings, including after when it was made clear that there could be a cap. Are you saying that the hospitals could never have raised that issue at a meeting and said, this is going to be difficult for us, and here's how? What do you mean by you could have never raised that issue?
Well, the cap was not communicated to the hospitals for the first time until October 1st. Prior to October 1st, there was a general condition discussed without specific numbers inserted. So there was no notice to the hospitals that they could have, that the board was contemplating limiting commercial rate increases at a per payer basis at a level that is low enough to impact the budgets. It wasn't until October 1st that the board actually told the hospitals what restriction it was proposing to impose.
Well, I would assume the hospitals didn't want any cap, right? So why didn't they object to when they knew there was going to be a cap, no matter what it was? How come at a hearing they didn't object to a cap, period?
Two responses to that. First of all, it really depends what the cap is. A 10% cap would be very different, presumably, than a 6% cap, where the proposal before the board had been for a 0% or a 7.1% increase. And
But couldn't that have been raised? Couldn't that have been raised in saying that if there's going to be a cap, that financially we can't respond, we can't exist with a number other than say 10%, 12%, whatever the number would be that would be preferred?
well, I think that all of this is requiring the hospitals to guess at what the board is proposing to impose as a cap. The fact is that the board did not even consider imposing this cap until after all of the proceedings on the hospital's budgets were complete. The hospitals didn't have any role in the subsequent process, other than, potentially to attend these hearings, which they're not required to attend. Their participation in the process really was already over by that point. They prepared their budgets, submitted them, presented them to the board and the public, and responded to questions by the board. It was only the board's deliberations that remained.
Mr. Chief Justice, may I ask one more question?
I
It's a
think
late
the
one.
time is not yet expired.
Oh, it's not yet expired?
I
Okay.
don't think so.
I thought, I'm sorry, I thought I saw the light go on. I apologize.
I think it was a warning and I'm happy to take your question.
Okay, thank you. Ms. Jensen? The cap, though, is a standard condition, correct? It's one of the standard conditions that the Green Mountain Care Board gives notice of. There are standard conditions that they will accept a budget, and it says clearly, subject to standard conditions, and a rate cap is a standard condition, is it not?
This is a standard condition, so-called, that the board adopted for the first time in 2023. So the board even acknowledges that this was a new condition. We haven't done this before. There were a lot of questions about it. So had they done it for, fiscal 25, it might have been a different situation. The hospitals could have responded.
So your point is calling it a special condition doesn't make it one. Or
Absolutely
standard
correct.
condition, I should say. Thank you.
Okay,
Thank you.
thank you very much. We'll hear from Council for the Appellee now, please. Council, if you would, introduce yourself and identify your, and then proceed.
Thank you very much. Good afternoon, Your Honors. Mr. Chief Justice, members of the
afternoon.
court. Brian Kane on behalf of the Green Mountain Care Board.
Thank you.
The Green Mountain Care Board lawfully imposed this commercial rate cap at issuing these appeals as a standard condition on every hospital budget in order to fulfill its statutory obligation to ensure that financing of healthcare in Vermont is fair and equitable, and that smaller Vermont-based nonprofit companies are not disadvantaged compared to larger national for-profit insurance companies who may have more leverage in negotiating rates with hospitals.
Mr. Kane, I didn't have a chance to ask your opposing counsel this question, but you're surely aware that we had earlier today another appeal involving the authority of the Green Mountain Care Board. Does that, and if you are aware, let me ask you if that appeal intersects with this one in some way in your view?
They're separate regulatory oversight statutes and processes, but I think the general principles, there's certainly some overlap there with respect to the obligation for parties to preserve their arguments before the Green Mountain Care Board, and with respect to the purpose and function and authority of the Green Mountain Care Board as it serves this vital function of protecting the citizens of Vermont and the public good by ensuring that all healthcare financing administration is fair, equitable, and that costs are maintained. But with respect to the specific legal provisions at issues, there's not substantial overlap between the One Care case and this one.
Yeah.
With those lofty goals in mind, Ms. Jensen says that the fact that you call this a standard condition doesn't make it a standard condition. So what is it that makes the rate cap a standard condition other than the fact that the board decides to call it?
Well, first, Your Honor, I'm not sure whether you characterize it as a standard condition or a substantive condition, or whether there's any distinction between the two is material to the issues in the appeal with respect to notice, due process, and the board's authority. But as a matter of fact, the reason it was called the standard condition is because the board elected to impose it as part of every single budget. And they did so, and this was explained by the board staff at the August 30th and at subsequent meetings. The board's understanding was that when hospitals request a rate increase in commercial rates, and the board sets a percentage saying you can increase those rates by 5%, that be the rate percentage that is then articulated and charged to the payers. And certainly they can negotiate below that. But if you say, allow us to charge 5% more, that you are then charging 10% more to certain payers. So that was explained as the purpose for the condition, and that purpose is equally true for every single hospital budget that they approved. And so they made clear that when we set your commercial rate increases, it's intended to be a cap. And whether that's a new condition, whether that's what they always understood is frankly irrelevant, because as this court's already noted, from the August 30th meeting on, every single presentation included this PowerPoint with the exact language of the proposed standard condition that set it forth clearly as a per payer cap.
Without the specific number.
Without the specific number.
But would you agree that there was going to be some number in there?
Yes, absolutely. And in fact, the number that was included in those was the number that was provided by each hospital budget as their requested increase in commercial rates. So I think, Justice Cohen, your point is well taken. And to the extent that this language was, again, included in every single public meeting, if they thought that the number needed to be something different from what they proposed in their budget, then they certainly had an opportunity and should have said so. And the obligation under the board's rules, 3306, puts the obligation on the hospitals to have the burden of demonstrating that their budget should be approved. So they certainly knew that a per payer cap was going to be put into place, and they never presented any other number other than the commercial rate increase that was included in the budget
But
proposal.
it's not necessarily per payers, for commercial payers. It's limited to commercial payers, is it not?
I think that's all the commercial rate increase applies to. Yes,
And that would be medical insurance companies,
yes, correct, Your Honor.
health insurance companies.
Yes.
So is it your position that the hospitals had an opportunity between the 30th of August and October 1st to raise some specific objection here, and they did not?
Certainly, Your Honor, and that's the point of the process. The hospital's argument effectively puts the cart before the horse and says, we need to know the specific conditions that you'll oppose at the end of the process before we even create the budget in order for there not to be a due process violation. And that, undermines the entire purpose and the schedule and everything that is set forth by the legislature and the board's rules for that period of time at which there's public meetings, public comments, health payer advocates. Many people participate in the process of reviewing these budgets, provide input, and then ultimately that leads to a decision. So the notion that somehow they needed to have known of the specifics of the cap at the outset, it's simply there's no requirement in due process or other requirement of law that be the case, and that just doesn't make sense.
Well, then perhaps you could explain to me what this whole situation is regarding the earlier statements that your budget is approved as submitted. Why does that happen weeks or months before the written budget approval is given?
Well, Justice Carroll, I think is absolutely correct. It was as submitted, subject to the standard conditions. And so it was clear from the outset that the approval was subject to these conditions. And again, the only commercial rate increase that was ever discussed by the hospital was the one that was adopted and plugged into the condition in that number is the one that they requested. So did that answer your question?
I think so.
To go back to the thrust of the arguments relate to this due process violation. And I think, Chief Justice Reiber, you're correct that the guidance at the outset, that language that the board would consider and possibly adjust commercial rate increases is sufficient to meet the standards of due process. This court has routinely held that all the notice that's required is that sufficient that the parties be appraised of the nature of the proceedings such that it avoids unfair surprise. And that simple statement at the outset of the guidance that we are going to be looking at your commercial rate increases is enough to put them on notice as to the nature of the proceedings. But again, even if it weren't, there was substantially more notice than that in the form of every hearing, including the exact language of the proposed standard condition.
Can you tell us how these hearings work? Are these public hearings? Do they invite public comment during the hearings?
Yes, they're public hearings, they're noticed as open meetings, there's opportunities for public comment. And I think that actually weighs in favor, if anything, of broader opportunities to have raised these issues. The informality of it, it's not like a court proceeding where, only parties can, say things through their lawyers, and there's specific timeframes or rules for filing specific motions. Here, it was a very open process, so the hospitals engaged in that process and certainly had ample opportunity to object to this cap at any point in the proceeding. And frankly, they could have done so even after the proceedings. They did, in fact, raise some sort of questions about how it was to be interpreted. And the board subsequently had a public meeting on October 27th where some of those things were discussed. And it's actually in the record at that hearing, immediately before the discussion of the cap with respect to these two hospitals, a different hospital asked for the standard condition A to be adjusted. They said, we think that the board intended for A and B to correlate. This is at pages 296 to 300 of the Rutland printed case, and it deals with the Northeastern Vermont Regional Hospital. And they sent a letter to the board after the written decision and said, we think this condition is incorrect. Could you please fix it? And it's actually in the record that for that hospital, the board did just that. They considered it and they moved to amend condition A with respect to that hospital based on that motion. So there was certainly ample opportunity throughout this proceeding for the hospital to articulate to the board any objection to the standard condition and the per payer cap, even at the specific percentage it ultimately ended up being in. And their failure to do so, I think, violates the purpose of preservation, which is to give the board an opportunity to evaluate and to rule on the matter in the first instance. So absent the due process violation and assuming that these were preserved, looking at the substantive authority to impose this condition, I think this court needs to focus heavily on the standard of review of the board's decisions, which is highly deferential. And the board's decisions are presumed correct and valid and reasonable and will not be overturned unless there's a clear and convincing evidence to the contrary. This court held that in INRI ACTD LLC and INRI Professional Nurses Services Inc. 1. So under that standard of review, the board had authority. There's no question that they had authority to regulate and to govern commercial rates, and that there's nothing in the record that indicates that there was some abuse of discretion. There's certainly not clear and convincing evidence that would indicate that that exercise of that authority was somehow unlawful or invalid. With respect to the argument that especially with respect to Northwestern, that the budget indicated that this was intended to be an average, right? That they specifically articulated that across different service lines, one is going to be a 7.1% increase and another one is going to be a 0% increase. Nothing in that averaging is inconsistent with the cap. Averaging across service lines based on their assumptions with respect to the utilization of those services, and nothing in that impacts the individual payers, assuming that they're covering Vermonters similarly situated. So the notion that somehow the board should have known that they intended it to be an average, not across service lines, but across different payers, in that we're going to charge one insurance company a greater amount of money for the same class of services and another one less. There's absolutely nothing in the budgets that articulate that. And the fact that they did articulate that it was going to be an average with respect to service lines, I think illustrates that they understood that they could have articulated that with respect to charging and negotiating different commercial rates with different payers, and they didn't do so. So their obligation, it's on them to justify their budgets, and to the extent that they took issue with the per payer cap, because they intended, and they knew from the outset that they intended to negotiate different rates with different payers, some of which might be above what they requested as a rate increase. There's nothing presented by either hospital to put that before the board and give them an opportunity to evaluate that.
Do the submission of budgets require a percentage number about rate increases?
I believe, yes. I think that they have to submit information with respect to any change of charge and commercial rate increases.
Okay.
But how they do that is not, I don't think, specifically articulated.
Thanks.
If there are no further questions, this court will confirm the decision of the board.
Thank you very much. Does the appellant have any time?
Helen has no time remaining.
Okay, thank you both. Please.